one of the things that seems evident at this point, so for example, on that shadow docket, Justice Alito said, I care about three things: discrimination against religion, racial inequality, and suppression of speech for the content of the speech, just those three. So one of the things that I think might be signaled there is that when a direct religious belief clashes with racial equality, the justices intend to stand by a almost 40-year-old opinion in Bob Jones University against United States, which resembles in some ways. Fred's story made me think of the case, in part because Bob Jones first refused to admit all Black students, and then would admit them, but only if they never engaged in interracial dating relationship. And that was the rule that was in place when Bob Jones was decided. And the case involved the tax-exempt status of the university, which was removed unanimously by the Supreme Court in 1983. That has remained a deeply controversial decision among some branches of American religious life. Many evangelicals say, well, we don't support racial discrimination, but that was the wrong decision. Sort of not defending Bob Jones, but attacking the court for its aggressive status action against racial discrimination. So one of the things to think is, well, maybe you really need your own constitutional amendment before you get protected as having a particular civil right in this era. And it is deeply concerning. It will be interesting to see how this plays out, and nail biting, I think, is the other thing I'd want to get across. We're all on edge.
Thank you. Beth, of course, to you.
Yeah, thank you. First of all, let me thank Sally, because I tell my graduate students, I teach Bob Jones at the beginning of my graduate law and public affairs class for a number of things. And at the end, I say, everything comes back to Bob Jones, and then we link it back. And so you have just validated that for me. So for any of my graduate students who are listening, it really does all come back to Bob Jones. So there you go. Just a couple things I'll add on, or echo, really. I do think that the expansion of the ministerial exception is something to watch here. That feels quite aggressive by the Supreme Court, and especially when statutorily we have a variety of accommodations already for religious institutions and actors in the non-discrimination laws. And so to add on to that, this what feels like increasingly broad gloss is something absolutely to watch. And one thing in that regard that's been quite interesting is to see how the lower courts are struggling with what they do with the expansion of that exception. So for example, it's one thing when you have an employee at a religious school, for example, who says that they've been fired in violation of a non-discrimination law. But what about when they're saying they're being harassed, sexually harassed, or harassed in some other way? And the lower courts have split on whether they're going to, if you're a minister, if your function is religious enough within the organization to consider you a minister, whether they just reject those claims out of hand, or whether they will go a little further to see whether there is any conceivable religious basis for the claimed behavior, because presumably at some point, a school will say, well, it's actually no part of our religion, perhaps, to engage in this kind of behavior, or, they'll have to defend it if they're saying it is. So I think the lower courts are struggling a bit with the expansion of that exception. And of course, the Supreme Court only hears a relative handful of cases. So for issues to bubble up to it ultimately to provide guidance, there's a lot going on in the lower courts for many years before we get another, I would never say the final word, but another chapter from the Supreme Court on this.